couple aspects of what I anticipate to be the scoring challenges, and also a concern I had about credit on the plea agreement. And also the prosecutor advised me that the minor victim is present in the courtroom and does want to make a statement. And after consulting with her mother, with the victim rights person in the prosecutor's office, and with counselors or helpers from the Women's Resource Center, does wish to make that statement in open court with the matter being live streamed. Even given her age, it's important to her and her family that the community know about this offense. Is that correct, Ms. Goodrich?
That is correct.
All right, Mr. Johnson, scoring challenges. Go ahead.
Your Honor, as to the 25-6978 FC case, as indicated, we'd object to OV 11, reasons discussed off the record, OV 13.
In the other file.
In the other file, we'd object to OV 13 being scored.
So as I understand, Ms. Goodrich, then, and we did discuss this at the bench, but for the record then, in the 6978, the CSC third, OV 11 was scored at 50 points for other sexual penetrations. However, those would have to be other sexual penetrations arising out of the same transaction of the sentencing offense. And I didn't see sufficient evidence of that. So I would, it wouldn't count the whole course of conduct. It'd have to be arising out of that event itself. There were multiple penetrations at the same event, for example. So I'm inclined to agree with the defense objection on OB 11. Anything contrary you want to place on the record, Ms. Goodrich?
No, Your Honor, thank you.
Okay, so in 6978, OB 11 will be scored at 0 points rather than 50. The defense also objects in file 7035 to the scoring of OB 13 at 25 points. That's properly scored in the 6978 as the offense, the CSC third, being a part of a pattern of offenses involving criminal sexual penetrations or crimes against a person. But in the 7035, it being a conspiracy to obstruct justice, that's a public safety or public order crime. So therefore, it itself would have to be part of the pattern under the case law. And so I'm inclined to agree that OB 13 should not be scored at 25 points. Do you have any position with regard to that, Ms. Goodrich?
No, Your Honor, no objection.
Should it be scored at any points at all, or?
Your Honor, it's our position for the 25-7035 FH, it should not be scored.
Okay. Oh, that's correct. Okay, I was confusing it with OB 12 about other crimes of any kind. Okay, so in file 7035, OB 13 will be scored at 0 points rather than 25 points. I'd sustain both those defense objections. Any other scoring challenges from the defense?
No, Your Honor.
Ms. Goodrich, any scoring challenges from the people?
Your Honor, in both files of PRV 7, there was more than one felony pled to. So I'd ask that it change to reflect that.
Okay, so Mr. Johnson, any defense response to an objection to scoring of prior record of 7 being underscored?
Your Honor, as to 25-6978, my client did plead to more than one count, so I believe it should be, that one should be 20 points for the second count on that offense and a subsequent conviction for the other case. As to, I'm sorry, I'm looking for the case number.
7035, the obstruction.
At 7035, the obstruction, it was only one conviction, and there was no other conviction after that. So I think that one should remain at 0.
Okay, in both files, I'm going to score prior record variable 7 at 20 points for concurrent or subsequent convictions. This defendant pled to 3 felonies across 2 files total, but 3 felonies total. So when we're scoring the CSE third, there are 2 concurrent felonies. 1, the CSE 2, and number 2, the conspiracy to obstruct justice. When we're scoring the conspiracy to obstruct justice in file 7035, we again have 2 concurrent felony convictions. First, the CSE third degree, second, the CSE second degree. So in both files, PRV 7 will be scored at 20 points. Ms. Goodrich, any other scoring challenges?
Your Honor, in the obstruction file 7035, I would ask that OB 14 be scored for 10 points for the defendant being the leader in that situation.
Mr. Johnson, defendant's response.
Your Honor, and of course, the burden of proof is about preponderance of the evidence here. The court has to determine what is a leader. My client was in jail. He had no ability to write the letter, deliver the letter, participate in any of that. Now, because he may have wanted the crime to occur, well, that makes him an aider and abettor or a co-conspirator. Even if I suggest to someone, we should rob the local bank, it may be my suggestion. I may be the one that puts that out there. But if somebody else does the planning, somebody else gets the car, somebody else gets the weapons, the mask, and those things, then that person, or whether charged or not, has encompassed the role of a leader. Based on the facts here, although the crime may have been for the benefit of my client, and even the court finds that my client may have been the one that wanted the crime committed, when looking at the facts of what was done, what had to be done to attempt to commit this crime, my client could not have been the leader because he was prohibited from doing any of the planning. He had no access to the computer that was at the job and forging this letter. So we do not believe that there are sufficient facts to suggest that he was the leader, although he was the beneficiary, we would have been the beneficiary of the alleged crime.
Okay, in this case, the conspiracy to obstruct justice charge is based upon facts that while the defendant was in jail, charged with the criminal sexual conduct, he asked another person to fabricate a letter from I think the mother of the complaining witness to present to the prosecuting attorney, which purported to say that she had pressured the victim into making the statements, and so it was offered as exculpatory evidence, and it was fabricated. And so he's been charged and convicted for conspiring to obstruct justice by doing that. I think on a preponderance of the evidence, that's a little bit different than 2 people talking on the outside, like, gee, should we rob a bank or not? And one of them goes and does it. The one who suggests it is not necessarily a leader. I don't disagree with that. But in this case, somebody who's charged with a crime, who then asks somebody on their behalf, I want you to go fabricate this evidence for me, and they do so. I think the defendant who's charged with the crime and is instigating the fabrication of evidence is in fact a leader in a multi-offender situation. So I would find on a preponderance that Mr. Truman was a leader in that situation. So OB 14 in file 7035 would be scored at 10 points. Any further objection to scoring for the people?
No, Your Honor.
So now we got to do more math. In file 6978, I've added 20 points to PRV 7, which brings the PRV level from 25 to 45.
As the courtroom listened to the victim's mother, the depth of the pain was undeniable. The defense pleaded for leniency, while the prosecution pushed for the maximum sentence. Every word carried the weight of a family's broken trust.
45 on grid B, which still is prior record variable D, or prior record variable level D. And offense variable, I've scored OB 11 at 0 points. That's reduced the total OB from 95 points to 45 points, which reduces the level from 6 to 4. So the guidelines range would no longer be 84 months to 210 months, but would instead be 72 months to 180 months with the habitual 3rd taken into account. Is that math correct, Ms. Goodrich?
Yes.
Mr. Johnson?
Yes, Your Honor.
Okay, and in 7035, again, I've added, this is on Class E grid. I've added 20 points to PRV 7. That increases the total PRV from 35 to 55, which changes it from prior record variable level D to level E. On the offense variables, I've scored OB 13 at 0 points rather than 25, but I've added 10 points under OB 10. So I think that means total OV would be 20 points. 10 for OB 14 and 10 for OB 19. That means that the level is from 4 to level 2. Is that right? And that would reduce the range. We're at E2. That would be with the habitual 3rd. Now, instead of 12 to 36 months, it would be 10 to 34 months. Is that math correct, Ms. Goodrich?
Yes.
Mr.
Yes, sir.
Johnson? Okay. All right, so now we have our advisory range. Mr. Johnson, anything you want to say on behalf of your client?
Your Honor, starting with 25, 70, 35. The court has already given, as part of the guideline objective recitation, what had happened. My client should not have engaged in that. One of the things that is important to everybody involved in the judicial process is that the process, is fair. And there are no outside influences on the evidence or from one side or the other. And I know from the government standpoint, that is the chief evil of falsifying or trying to manufacture evidence of guilt. And the court, in fairness, should look at it the same when a defense defendant does do it. But I would like to state for the court that the obstruction of justice is the sentencing offense, and he gets an aggravated factor under OB 19, 10 points for interference with administration of justice. And I fully concede that at this point, courts of higher jurisdiction have not agreed with the defense positions that you're really giving somebody an aggravated factor for what is essentially a sentencing offense. When you look at the totality of circumstances, we'd ask the court to follow the recommendation, and on that matter, sentence my client to fines and costs. As to 25, 69, 78, FC. I do not believe, after getting to know my client, that he is the person that he appears to be on the screen. And I say that knowing full well that we are here now for the second time in which he will be sentenced on a sex offense. And I say that understanding that, he has pled guilty or to violating the trust of someone that should have been able to trust in him for protection. When my client is embarrassed, he is hurt for the hurt that he has caused. He has, accepted responsibility. He's, waived his exam. He's pled guilty and accepted responsibility for these offenses. He was blasted all over social media for this offense. He's going to be on the sex offenders list. And these type of cases, and as a product of Catholic school, all through to college, and when I talk to people and they talk about, or I talk with them about Catholicism and criminal defense, it really focuses on a principle that I believe that nobody's sin is greater or lesser than anyone else's. We've all sinned. We've all fallen short, in my opinion. Now, the law does not take that opinion. We have Class A felonies, Class B felonies, Class C felonies, Class D felonies. I understand.
I'm a lapsed Catholic, but I was taught about venial and mortal sins, so I'm not sure that canon law agrees with you too, but we're not going to get into that, but adjudicating that question today. Go ahead and continue.
Thank you, Your Honor. My client, I do believe, is redeemable. I do believe that he has started in that first step of conviction and repentance, and here accepting responsibility, acknowledgement of what he has done. And he knows that he can never make right what he has done. But he is here, he is ready to accept his sentence. We ask the court for a fair sentence, and based upon the guidelines, my client's previous record, we would still ask the court for what it is that we were initially going to ask. We know the minimum has now been lowered based on changes to the guidelines, but it was never our plan to come here today and ask the court for the minimum sentence. We still ask this court for a sentence of 90 months for the capital case, which I believe is fair, looking at the account of my client, with this not being his first criminal conviction, not being his first sex offense, but taking into account that he did step up and take responsibility for the harm he's caused, knowing the understanding that it's not going to make it any better. The fact that he did that, he should have done it in the first place. But we ask the court for a sentence of 90 months.
All right, thank you. Mr. Truman, you don't have to make a statement today, but it is allowed. Is there anything you want to say today, sir? No, sir. All right, so it says Paula's iPhone. Paula, we didn't want to put your daughter's image and statement on YouTube. She did just make a statement in open court. The prosecutor tells me that if she did so, that you possibly did not want to make a statement. Did you wish to make an impact statement at this time or no?
We were hoping that both of us could, but they weren't sure how that was going to work today. So
that's fine. If you want to make a statement, go ahead.
Absolutely. All right. So I'm here before you today to express the profound impact that this situation has had on my family. And the actions of Elmer have not only inflicted fear and trauma on my daughter, but they have also disrupted the very fabric of our family. My daughter endured suffering that no one, especially a child, should ever have to face. Witnessing her pain has been unbearable as a parent, and it breaks my heart to see the confusion and fear in my child's eyes. This has fundamentally changed how my children view the world. They now carry the weight of this trauma and lingering fears. Elmer's actions, having his wife writing a letter pretending to be me and trying to make me look like a monster to my children, is just inexcusable. I feel as though a dark cloud has been looming over our family, making it difficult to foster a sense of safety and trust. The trust we once had as a family has been shattered, and rebuilding it is going to take some time and a lot of support. The damage done is immeasurable. My daughter has lost precious moments of her childhood, moments that she will never get back. We're asking the court to impose the maximum sentence allowable, not only because Elmer deserves to be held accountable for his actions, but also to signify the pain that he has inflicted on our family. And that is recognized and taken seriously. We ask that he serves consecutively and the maximum penalty. I hope that through this process that my family can heal and create a future where my children can feel safe. So I thank you for taking the time to consider, our statements today with the impact that it's had on us.
Thank you, ma'am.
Thank you.
Okay, and before I take the prosecutor's recommendation, as we're hearing more about this letter, it does cause me to revisit one scoring question. On the CSC case, 6978, OV 19 was scored at 0 points. However, OB 19 is not subject to the McGraw limitation of scoring facts only for the sentencing offense, but for conduct afterwards. And